I still remember the day I realized my estate plan wasn't as rock solid as I'd thought. It was a sunny afternoon, and I was sipping tea by the window, feeling proud of the life I'd built. At 87, I had worked hard for decades, raised a wonderful family, and hoped to leave a legacy that would carry my name and values forward. That afternoon, a phone call from my nephew changed everything. He mentioned a distant cousin who had fallen prey to unexpected legal challenges. Her assets vanished almost overnight, eaten up by claims and court fees. I hung up the phone with a jolt of concern, my thoughts spiraling. If this could happen to her, what about me? The more I dug into it, the more I realized that many seniors, even those who consider themselves well-prepared, are shockingly vulnerable. There are laws and loopholes that can uproot everything in the blink of an eye if the proper documents and strategies aren't in place. For a few sleepless nights, I paced around my living room in silent dread, imagining the worst. Losing the home I've loved for over 50 years. Leaving my children and grandchildren with nothing but a mess of legal battles. My pride bristled at the thought that after all I'd done, I could still end up helpless. Yet I refused to accept it. That stubborn streak that got me through life's challenges kicked in, and I decided to fight for my family's future. There had to be a better way. That's exactly what I want to share with you today. The estate planning strategy that saved me from falling through the cracks, and the 5 key points that will help you protect what you've spent a lifetime building. We'll discuss the common myths that lead many older adults into painful missteps, and I'll show you how a simple shift in how you view your property, your documents, and your rights can save you thousands of dollars and countless headaches. By the end, you'll be equipped to stand taller with a clear plan, confident your wishes will be honored. The final tip in particular is a game changer, one so few seniors know about that it's almost a guarded secret. Everything I'm sharing has been gleaned from my personal journey, along with insights from attorneys and financial planners who specialize in helping people just like us, individuals who've worked too hard to let the system unravel our dreams. These pointers aren't general theories, they're tested, real-world strategies. That call from my nephew led me down a path of thorough research, discussions with professionals, and a deep dive into the stories of seniors who've either thrived with smart planning or suffered because they overlooked just one crucial detail. Before we get started, I'd love to invite you to join our community here. If you find this video valuable, please consider subscribing and turning on notifications. It's a small step that ensures you won't miss the practical advice that can keep you and your family safe. Your engagement helps others see this information too. So if at any point something resonates with you, leave a comment. Type a quick 1 if you find a tip helpful or 0 if you disagree, so I know what's working and what isn't. Now let's walk through the 5 main points that transformed my shaky plan into an unshakable shield for my family's future, and how you can do the same for yours, no matter if you're 65, 85, or anywhere in between. Because let me tell you something, the dignity that comes with knowing you have a safety net in place is priceless. It preserves not only your bank account, but your sense of self-respect, reminding you that age doesn't have to mean vulnerability. Point number 1 is all about letting go of what I once believed was the hallmark of a traditional will. For years, I thought the simplest route was the best. One straightforward will, and that's that. But I discovered a fundamental flaw in that thinking, one that almost cost me my home. Let's dive in. I used to believe, like many people my age, that if you draft a will, you've covered all the bases. It's the time-honored approach. Put everything in your will, appoint an executor, and trust the process. But here's the bold truth. A will alone isn't enough to protect you from probate court challenges, estate taxes, or unexpected claims. Yes, it's essential to have one, but if that's your sole document, you might be unwittingly handing a chunk of your assets over to legal fees and delays. Too many seniors misunderstand probate. They think it's just a quick process where the court validates a will and distributes the property. In reality, probate can be slow and complicated, often leading to contested claims if distant relatives or even opportunistic acquaintances decide to challenge the distribution. I know one man named Arthur, 79, whose will stated that his modest estate should go to his daughter. After his passing, An estranged family member contested the will with a half-baked claim of promised inheritance. That single objection led to a protracted court battle, draining thousands of dollars in legal costs. Arthur had no trust in place, no additional layers of protection. His daughter spent over a year fighting, and her relationship with other relatives frayed in the process. The heartbreak overshadowed the grief of losing her father in the first place. The surprising insight is that a living trust can bypass many of these pitfalls. A trust helps your estate avoid probate altogether. Once you place assets like your home or savings into a properly established trust, those assets are distributed according to your instructions, privately and with minimal court involvement. The real beauty is the peace of mind it brings. You have the power to outline exactly how your assets should be handled if you become incapacitated, ensuring no forced government oversight or lengthy legal fights. So the practical advice? Don't rely on a will alone. Research living trusts, sometimes called revocable trusts. Talk with a financial planner or estate attorney about which form best suits your circumstances. You'll likely need to retitle some assets, like changing your home's deed to reflect trust ownership. But this small step can create huge benefits, and it doesn't mean you lose control. A revocable trust allows you to manage and even sell your property as you always have, right up until you pass or become unable to handle things yourself. On an emotional level, setting up a trust is an act of empowerment. You're telling the world, I've taken charge. I am ensuring my wishes come to pass without a parade of legal drama. It's a declaration of self-respect and concern for your loved ones. There's a sense of pride in saying, yes, I'm older, but I'm still calling the shots. Point number 2 focuses on something I used to brush off: detailed healthcare directives and powers of attorney. People think estate planning is only about money, but your health is arguably your most precious asset. Here's my bold statement. Ignoring healthcare directives can lead to heartbreak just as surely as ignoring your finances. I once believed that a quick conversation with a close family member was all I needed. Hey, if anything happens, you know what to do, right? That's a dangerous misconception. Verbal agreements are easily misunderstood and hold no legal weight in a crisis. Even if you think everyone in your family is on the same page, fear and stress can prompt disagreements when critical decisions must be made. Let me share the story of Emily, 85, who lived a vibrant life until a sudden stroke left her barely able to speak. She had never formalized her wishes. Her 2 adult children each had different recollections of her preferences for care, and neither had official authority to act on her behalf. While they argued about whether to authorize certain procedures, valuable time slipped away. Hospital staff, bound by regulations, couldn't honor a verbal statement Emily had made months earlier. The conflict culminated in bitter tension that lingered long after Emily passed away. Her estate was overshadowed by guilt, regret, and legal wrangling over funeral arrangements. The surprising truth is that establishing power of attorney for healthcare and finances, alongside a living will or advance directive, is simpler than most people imagine. You outline your medical treatment preferences, designate who can make decisions if you're incapacitated, and specify what measures you want or don't want to prolong your life. Many states have standardized forms that can be completed with a notary's stamp. The practical advice is straightforward. Call your healthcare provider or local senior center and request these forms, or consult an attorney who handles elder law. Fill them out when your mind is clear, your heart is calm, and you're free to focus on the values you hold dear. Doing so ensures no one will question your directives in a hospital setting. And never forget to discuss these documents openly with the person you've chosen as your agent. This fosters understanding and confidence. So if crisis strikes, the people you trust won't hesitate or bicker over crucial decisions. Beyond the legal aspect, it's a profound emotional gift to yourself and loved ones. Taking charge of your healthcare destiny says, "My dignity matters enough that I won't leave it to chance." This fosters deep respect, both for your own life and for the people who may one day need to stand in your shoes. Now, if you found these first 2 insights helpful, I'd love to hear from you. Type the number 2 in the comments to let me know you're still watching and that this information resonates with you. And if you haven't yet, consider subscribing and turning on the bell for notifications. Together, we can build a robust community that looks out for one another. Point number 3 highlights something that cost me a lot of sleep: the misconception that joint ownership is always the safest and easiest route. You might have heard that naming a child or grandchild as a joint owner on your home or bank account is a convenient way to ensure they inherit without complications. While joint ownership can have its benefits, it's far from a one-size-fits-all solution. The bold statement here is that adding joint owners to your property can actually place your assets at greater risk. Why? Because the moment someone is named a joint owner, their financial or legal troubles can become yours. Imagine if your daughter, who's co-owner on your house, goes through a messy divorce or faces a lawsuit. Suddenly, your property might be entangled in legal battles, or if your co-owner racks up debts, creditors could come after property that's jointly held. I've seen it happen to dear friends who only intended to streamline inheritance. Instead, they ended up fighting to keep their homes out of someone else's claim. Take Roger, 72, who put his son's name on his bank account to help pay bills if Roger got sick. It seemed logical, but when his son lost his job and defaulted on a loan, creditors froze the account Roger depended on to cover daily expenses. Roger spent countless hours clarifying the ownership, draining his energy and finances at a time when he should have been focusing on his health. The surprising truth is that well-structured estate tools, like payable on death, POD, designations for bank accounts, and transfer on death, TOD, deeds for real estate, can achieve the same goal without exposing you to someone else's financial woes. With POD/TOD, your heir automatically inherits upon your passing, bypassing probate. During your lifetime, the asset remains solely in your name, so if your child faces lawsuits or divorces, it won't affect your property. The practical step is to review any joint accounts or jointly owned property you have. If the main reason for joint ownership is estate-related, explore those safer alternatives. You'll likely need to fill out specific forms at your bank or the local courthouse for property deeds, but it's far less complicated than dealing with potential legal snarls down the road. Talk with an attorney about how these designations might fit into your broader estate plan. Emotionally, there's an immense sense of relief in knowing you're protecting not only yourself, but also your loved ones from unforeseen liabilities. When you choose the right legal arrangement, you eliminate guesswork and shield your family from future drama. It lets you say, I'm handling this like a responsible guardian of my legacy, which preserves not just your assets, but also the peace and dignity everyone deserves. Point number 4 delves into a hidden pitfall: underestimating how taxes and long-term care costs can devour even a modest nest egg. Conventional wisdom says, oh, if my estate isn't huge, I don't have to worry about taxes, or Medicare will handle my medical bills. Neither assumption is completely true. The reality is more nuanced, and ignoring it can be a recipe for financial disaster. The big misconception: only the wealthy need to fret about estate taxes. While federal estate taxes do affect larger estates, state-level taxes or inheritance taxes can hit smaller estates depending on where you live. Plus, nursing home or assisted living costs can run thousands of dollars a month. If you require extended care, your hard-earned savings can vanish rapidly unless you plan ahead. Consider Irene, 83, who assumed her moderate bank balance and Social Security income would see her through. She hadn't looked into long-term care insurance or Medicaid planning because she felt that's for folks with money. After an unexpected fall, Irene needed specialized rehab that lasted nearly a year. When her Medicare coverage ended, she found herself paying out of pocket. By the time she was ready to return home, most of her savings were gone. The saddest part? Irene's children were forced to sell her beloved cottage to cover remaining expenses. She told me, I worked all my life and never thought a single accident could cost me everything. The surprising insight is that there are legitimate ways to protect your assets from these scenarios. Medicaid planning, for instance, allows you to reposition certain assets so they won't be counted when you apply for government assistance. However, it's crucial to start early because Medicaid has a look-back period, often 5 years, where they examine your finances for certain transfers. Also, specialized insurance products like long-term care insurance or hybrid life insurance policies with a long-term care rider, can be lifesavers. The practical advice is to speak with an elder law attorney or financial advisor who understands Medicaid planning, tax shelters, and insurance. They can show you how to structure your property to minimize taxes and protect yourself from catastrophic healthcare costs. Even if you think you have modest means, the difference between unprotected savings and properly planned assets can be enormous if life throws you a curveball. On an emotional level, taking action here is about reclaiming a sense of security. We often think, if I've done everything right, I shouldn't have to worry. But the rules of elder care and taxation don't always reward good behavior. They reward smart planning. By addressing these issues, you preserve the independence and dignity of your later years, ensuring your finances won't dictate tough choices about where you live or how you receive care. If you're still with me and finding value in these tips, please type the number 4 in the comments. And if you haven't subscribed, go ahead and do that now. Every little bit of support helps us spread these messages and helps more seniors safeguard their future. Finally, point number 5 is the piece most people don't even realize they need until it's too late: planning for intellectual property and digital assets. You might be thinking, what do I have besides a Facebook page? You'd be surprised. In today's world, even if you're not tech savvy, you likely have a range of digital footprints, email accounts, online bank statements, maybe even a small eBay or Etsy side hustle. And if you've written a memoir or taken unique photographs, that's intellectual property. These can carry both monetary and sentimental value. The misconception is that digital assets aren't real assets, but the truth is they can be crucial for your overall estate, and ignoring them can cause chaos. Something as simple as not having the passwords to your online accounts can result in a digital lockout. Your loved ones may need to pay bills, close subscriptions, or manage your social media to prevent identity theft after you're gone. Or perhaps you have a self-published book generating royalties. Without directives, those earnings may get stuck in legal limbo. Take James, 68, who had a niche YouTube channel on gardening, bringing in a modest revenue. He passed unexpectedly without leaving instructions for how to access his accounts. His son spent months trying to prove ownership to the platform. It was a stressful ordeal, something James could have prevented with a few written instructions and legal documents. Eventually, the channel's income was lost because they couldn't prove rightful ownership soon enough. The surprising insight is that creating a digital estate plan isn't complicated. You can list your usernames and passwords in a secure location, either a physical notebook locked in a fireproof safe or a digital password manager. Then specify in your will or trust how these assets should be handled, who gets access, and whether you want your social media memorialized or deleted. If you have any creative works, talk to an attorney about intellectual property rights. This is especially crucial for folks who paint, write, or have family recipes they'd like to protect. From a practical standpoint, the solution might be as simple as an addendum to your trust or will, labeling your digital executor, someone who's comfortable with technology and able to manage these accounts. By doing so, you save your loved ones from frantic guesswork, hours of phone calls, and the risk that unscrupulous individuals could step in and exploit your digital presence. Emotionally, this is about pride and ownership in the modern age. You have the right to control how your personal story lives on in cyberspace. With a proper plan, you keep the memory of who you are intact, presented exactly the way you want. Maybe you'd like your grandchildren to keep reading your blog for years to come, or you'd prefer your online presence be taken down for privacy reasons. Either way, it's your choice, one that you deserve to make consciously and clearly. Now let's take a moment to reflect on everything we've discussed and why it matters so deeply. We began with the story of how I discovered a crack in my own estate plan after seeing how easily a relative's assets disappeared. We dug into the pitfalls of relying solely on a traditional will and why a trust might offer a safer route. We highlighted the critical nature of healthcare directives, because estate planning isn't just about money, it's about your dignity and independence at a time when you might not be able to speak for yourself. We explored the potential dangers of joint ownership, the harsh realities of taxes and long-term care costs, and finally, the often overlooked digital realm that also deserves protection. All of these points collectively paint a picture of proactive planning. Without them, you risk leaving your future to chance, allowing courts, creditors, and conflicts to decide how your story ends. No matter how old you are or how large or small your estate might be, these strategies can transform anxiety into a sense of calm and self-respect. Your assets are more than just money or property. They're symbols of your life's work, tokens of your resilience, and expressions of your generosity toward the people you love. I know what you might be thinking. Where do I start? Let me offer you a gentle push. Pick one of these steps, maybe the easiest or the one that's been lingering in the back of your mind, and tackle it this week. You could research living trusts or sit down with a friend or spouse to fill out healthcare directive forms. Maybe you'll finally schedule that appointment with an elder law attorney to talk about Medicaid planning, or perhaps you'll list your digital assets. Just one step can set the wheels in motion. Picture yourself 6 months from now with each of these points checked off your list. Imagine the weight lifted from your shoulders when you know, without a doubt, that your assets, your health decisions, and your legacy are shielded from the uncertainty that plagues so many seniors. Visualize the pride you'll feel as you watch your family breathe easier, knowing they won't have to sift through tangled paperwork or face legal battles. That sense of security is more valuable than any stock or property. It's peace of mind. If you found even one useful insight in today's discussion, I invite you to share it in the comments below. Let us know which point resonated with you the most and how you plan to act on it. Your experiences could inspire someone else who's feeling overwhelmed or unsure about where to begin. If you have concerns or questions, please share those too. I read the comments and do my best to offer guidance, and so does this wonderful community we're building. If you haven't yet, please like this video and subscribe so we can continue bringing you information that helps you stand strong and live with the dignity and pride you deserve. Every bit of your support, be it a like, a comment, or a share, helps us reach more seniors who might be struggling with these very issues. It's a small action on your part, but can lead to a ripple effect of empowerment and protection for countless others. Thank you for spending this time with me. You've taken a bold step simply by listening and learning. Remember, age is not a barrier, but a gateway to deeper wisdom and greater self-determination. With the right tools and knowledge, you can secure your legacy and honor the life you've worked so hard to build. I'm proud of you for being here. Keep going, keep growing, and know that it's never too late to protect what's yours and live the rest of your days with peace, pride, and dignity.